What's going on, everybody? This is Lady Luck here again. All right, time to discuss the buffoonery of Novatech. I wanted to do this in, a way where you guys, many of you can see what's happening with the OSC in these hearings, and to try to debunk a lot of this nonsense that people keep putting out there in their videos because they don't understand how things work from a legal perspective at all. I've done a video in the past on my channel where I go over cease and desist orders and the difference between a letter and an order, and who has the power to actually draft and sign and enforce an order. So you can Google online and research, but a government agency or a court of law both have the power to issue orders. And the OSC is a government agency that has the power to issue orders. They also have the power, just like SEC, the FTC, to conduct their hearings, to be able to present findings and exhibits for their case and bring forth the information in front of an adjudicator. The adjudicator is the equivalent to a judicial officer in the court. So this hearing is just as important as if it would be if you were in court. There's no difference. They both have the power to be able to conduct these hearings, to issue orders. They have the ability to summon people for hearings, to issue subpoenas. They can do all of that. So people need to stop thinking that this is just, something to belittle, because it's not. And then, of course, they can always get the courts. I know here in the U.S., the SEC could easily go to federal court and say, hey, we need to refer this over to you all for a criminal matter because of these contempts of a court order contempt of order that we issued. Now we need this to be, we've had an enforcement hearing. Now we need this contempt to be acted upon. We need a bench warrant order for someone's arrest. That can be done by a court. So these issues can become criminal if there is a contempt or violation of the order. I've said in my last video I did Novatech, or the one before that. But if you're in contempt of a court order, that's a crime. They can issue a subpoena and you can go to jail. So I think a lot of this is building up to where they can have other agencies and the courts to kind of collaborate with them on these types of cases. But a lot of this is building up to that. I mean, the OSC handles civil proceedings, but that doesn't mean that they cannot actually forward this over to a federal court or the equivalent of that in Canada to have it be pursued now as a criminal matter. And they can end up getting a bench warrant for their arrest. So I wanted to go over some of these documents that you all see online here. This is on the Capitol Tribunal website. You guys can see the case here. They have this information below is what I really wanted to go over. And this is why I also said that they don't have an attorney. So let's go through some of these documents and just do a brief overview of it so that you guys can fully understand why the last hearing may have been rescheduled, but the ones before that were not rescheduled intentionally. And there's a reason for it. Okay, so this is the August 24th filing here. It's a statement of allegations. Basically, the OSC is laying out the case itself, the issues that were brought before it, what they discovered from their investigation, evidence, any other witnesses, statements. Anytime you file your complaints, they take all that information and they try to help build the case. And that becomes, either goes to the finding of the facts. If you guys see here on section B, the facts are just flat out facts. These are indisputable statements that are presented in the case. Basically, it's like saying these are matter of facts that no one would be able to dispute, because it's just a flat out matter of a fact. It's a fact that these dumb peons started Novatech. It's a fact that they, did videos. Like, it's not overly convoluted. It's a simple matter of a fact. And that's what that section is all about. It's just facts, flat out. And then you can see, of course, they violated the temporary cease trade order. I told you guys they were in contempt of these orders anyway. And of course they're going to violate them because they don't care. I mean, that's what criminals do. So you don't expect a person who's a scammer to follow, orders. Of course not. So they don't even show up for a hearing. So of course they, are in contempt of the order. They issued a cease and desist order against them from Canada. Numerous times they've tried to conduct. This is, I think, their second major hearing they've tried to conduct on the allegations itself. And then you have orders sought. So this is what the OSC is asking the adjudicator to grant them as far as orders. And I know they were granted, but we're just going through it so you guys can see that. Now, if you look at this last page here, page 12, this is the the final page with the date. Normally, you will see in a actual hearing where you have two parties, you will see either the attorney's information representing those parties, or if it is a matter where one or both parties are pro se, meaning they don't have attorneys, then you will see that person's information. What you see here is the OSC and the litigation counsel representing the OSC. However, if these dumb peons had an attorney, you would see the attorney's information right next to it. On the other side, on the left-hand side of this piece of paper, right underneath the date. They do not have an attorney. Every motion, pleading, order that's signed would have their attorney's information on the last page of that document. So for people to keep saying ignorantly they have an attorney, if you understood these documents, you would see they don't ever have their attorney's information listed on any of these documents. And their attorney information is not private information. It is a matter of public information. You would also see, hold on a second. You would also see here, just like you can see an order on November 30th, order on September 28th, you will see an order of entry from their attorney. So in any other situation in real life, you go and you want to, let's say, you have a matter where you're being sued, okay? You go and get an attorney. The first thing your attorney files to the court is an order of entry. They're basically telling the court that they are your representative, your legal representative, and they will be representing you on your behalf. The court would have to have that order of entry. There is no way you can get an attorney and not see that order of entry where that attorney is representing you. And it has to be submitted. So in this case, it would have to be submitted to the OSC, to the adjudicator, to put on record. This is why I keep saying they don't have an attorney. This is what research also allows you to do. You need to be able to Google, how do you verify if a party has an attorney? And yes, that her attorney information would be public information. you will see the attorney's name, their bar number, and hopefully a bar certified and licensed. But you will see a bar number, and it will be typically their address, their phone number, basic contact details, and you will see that on the order of entry. So that would let the adjudicator or the court know this is where you to send summons, subpoenas, discovery material, anything that the petitioner or the defendant would need for their case. It would go to your attorney or your legal representative as opposed to you. So there's no order of entry here. So they don't have an attorney. Period. That is not something you skip. That is a standard piece of document and order that you would see in any case where there is legal representation. And all they're getting, get some understanding. So for people to keep lying about that is baffling to me. But if you have an order of entry, please present that information in your video, or stop saying that she has an attorney. She does not. Once again, I have not missed the mark on any of this. It doesn't make sense to keep lying about simple stuff, especially when anyone can just Google things, read it, and see, okay, well, I looked up what to look for if you want to verify if someone's represented. You're going to have that order of entry. An order of entry of appearance is basically the first thing your attorney will file. So you saw the statement of allegations, and then you get this notice of hearing for August 25th. A notice of hearing is exactly what it is. It's a notice of a hearing that's going to occur. That's it. So you will always see a notice of hearing in the event that there's a hearing, whether it be with the agency or with the court. This is standard. What happens is part of procedure. They have to issue a notice of hearing. This notice of hearing here was for September 28th by video conference. You guys can see this information. The purpose of such to address the statement of allegations that I just went over as the first document, that 12-page document. That's what this hearing was supposed to address, that statement of allegations. Of course, they failed to appear. They did not have any representation because they don't have an attorney. They do not have an attorney. There's no order of entry, and there was no attorney information listed on that statement of allegations as their representative. They also failed to appear as well pro se. If they can't afford an attorney in this civil proceeding, unfortunately, they have to be pro se. You're not guaranteed an attorney for a civil matter. You're only guaranteed an attorney for a criminal proceeding. So you don't get an attorney for a civil proceeding is like a luxury item. So of course they don't have one. So this is just a notice. Here is an order. Yes. This is the order that was issued on September 28th. As I stated before, government agencies and courts can issue orders. So for this government agency, the adjudicator is the equivalent to a judicial officer. And she signed this order because they can do that. So this says here, whereas on September 28th, Capital Markets Tribunal held the hearing by video conference, of course, because Dum Dum and Gum Gum didn't show up. And they hiding out somewhere, Lord knows why. But it's not going to end well for them. I mean, it didn't end well for Binance and FTX, Sam Bankman-Fried. It's not ending well for a lot of these people out here that's sitting around scamming folks. But yeah, they didn't show up. So it basically just kind of this order goes over what happened basically as a result of that hearing. It just reiterates the fact that, by 4:30 on November 17th, staff shall serve and file their notice of motion and motion materials with respect to waiver of service and further relief. By 4:30 p.m. on November 24th, the respondents shall file responding materials, if any, with respect to staff's notice of motion regarding waiver of service and further relief. A further attendance in this matter is scheduled November 27th at 9 a.m. by video conference or on such other date and time as may be agreed to by both parties and set by the Governance and Tribunal Secretariat. So at the end of the day, they gave them time to actually answer to the actual motion that the OSC had filed. Basically saying, okay, at this point, you can either appear for this hearing, present your discovery material. Both parties are, able to get an exchange of discovery. So you have the right to request discovery material from the accuser, whoever's bringing forth the allegations. So if they were to do the right thing for once, which they won't, but if this little girl was to try to do the right thing for once and decided to show up for a hearing of some sort, she would have the right to request discovery material from the OSC, and vice versa. She would have to present discovery material to the OSC. Or if she doesn't do that, she could be sanctioned. So this is how that works. There's no secret nonsense about this. If she had an attorney, the attorney's information would be made available to the public. You don't get privacy with your attorney's information. That doesn't happen. No attorney exists where they believe that their information should be kept private. They understand that they serve in the capacity where they're serving the public. So you don't have to release your private home address, but whatever your business address is. But you will see an attorney's information on these documents if they had one, and you will see an order of entry where the attorney themselves have filed directly to the adjudicator, to the agency, or to the courts, if this matter was in a court, to say, hey, I'm attorney so-and-so, this is my bar number, any documents you need to submit over for my client, please submit it to me, or email it, or file it, e-file it, however. She does not have a damn attorney. All right. So they filed a motion basically to try to waive, the certificate of service. They're tired of trying to send her summons because she's not showing up, and this matter has to move forward. And instead of them wasting time and money and resources trying to track her dumb behind down to serve her something, knowing she's not going to show up, they probably can't even find her at a viable address to serve her anything at this point. They're at a point where they're just tired of wasting their time and money trying to get her to appear for a hearing. But it does not stop the process from occurring. It will not stop the process from occurring. I repeat, it will not stop the process from occurring. At some point, this will be shifted over to a court of law. It shall be done. So, I always try to be honest in my videos. I'm not here to give hope to anything, because that to me is disingenuous, and it's a disservice to all those who have been scammed and lost their money. But you're not going to be able to get your money back from Novatech. You're just not. You're going to have to try to get a claim submitted, and ideally, they set up a disgorgement or a fund of some sort where you can get your money that way. They set up like a victim's fund, but it's not money that they've gotten out of these dumb peons. It's money that typically comes from either that government or private sponsors, like companies and organizations that, donate to these victims' funds. That's how you get the money back. It's not money that they retrieved from these scammers. A lot of times they don't recover depending on what type of scam it is. But in this situation, I don't see them recovering any money from these stupid peons. They don't have your money. They spent it. And now they're hiding out. Wherever they are, whatever they're doing. That's what they're doing. So there's no money to recover from them. So if you get any money, the best chance will be from some sort of fair fund or disgorgement through the OSC. And that money is not coming from what they recover from these dumb peons. Like I said, it will be coming from private sponsors and donors and government funding. That's it. That's how that works. All right, moving on. So just like I said, from that order that you saw, they had till November 17th, I think, to get the motion heard, and an order is sought. So they can basically say, hey, we've tried to get these idiots to come to court or to a hearing and they don't want to do it. So we're tired of trying to get them to do it. That's what this motion is about. The motion of staff of the Ontario Securities Commission here. Basically, in order waiving notice in the service of all future processes. You all see that there. In order waiving notice, this is what they're wanting. In order waiving notice in the service of all future processes on Novatech, that little girl, and continuing the merits hearing in the absence of the respondents pursuant to Rule 21, Sub 3 of the Capital Markets Tribunal Rules of Procedure and Forms, and S.7 Sub 1 of the Statutory Powers Procedure Act, RSO 1990 CS.22. So basically, they're citing rules, a procedural guide or a law, basically, and it looks like case law. No. These are just rules. No, this is OSC rules and then statutory powers of. Okay, so these are basically the rules that they're utilizing. So with these rules, every agency, they have their own rules. Like here, for instance, in the U.S., we have Uniform Superior Court rules. We have federal civil procedure rules. We have different types of rules based on whether you're dealing with something on a federal level, a state level, if it's with the court or if it's with an agency. They have their own set of rules that they follow when it comes to these types of proceedings. So they're using this pursuant to Rule 21 Sub 3 to say, basically, we have attempted on so many levels to serve these idiots, to get them to come to a hearing. They don't come. Now we're asking for an order so that we can waive that service to basically say we're no longer liable to issue any more summons to try to get them to appear for a hearing. That hearing that they were going to have on the motion allowed Novatech and this little girl to make some objection to that if they were to show up, but they didn't show up. So since they failed to show up for that motion, for the hearing on that particular motion, then now they're not going to get served anything anymore. They're not going to make an attempt to try to serve them any notices anymore. That's what the waiving notice and the service of all future processes mean. So anytime you serve a motion or anything or filing for a hearing, you have what's called a certificate of service. And that certificate of service is basically saying to the agency or to the court, we have tried to serve this document to this person by this method, whether it was e-filed and e-served or hand-delivered or served by a sheriff or some private private organization that serves, summons and subpoenas on behalf of the agency. However it's done, we're asking that we're no longer required to do that under this particular rule. And this is a rule that they can do. That's the same thing that can happen in the U.S. So you can, look up we have federal procedure rules that we have. And it gets to a point where if it's time consuming and it's a waste of resources to do that, because you got to pay these people that are serving these notices or these summons for a hearing to actually go out, travel, and to try to find this person at their last known address, which these dumb peons have listed in Florida. Mind you now, this is the OSC hearing in Canada. So they have to travel to Florida to try to serve them a summons in Florida at their last known address. They're not going to keep doing that. But it does not stop the proceedings from moving forward. And as you can see here, after Cynthia Petition, collectively the respondents, and continuing the merits hearing in the absence of the respondents pursuant to Rule 21 Sub 3. So this is not going to stop. They're going to continue on on the merits of this case, on the facts and the evidence, the exhibits that they've gathered, which is over like 50 exhibits. And I pointed that out from their cease and desist order in an earlier video. They have over 50 exhibits. So they can have a ruling done in their absence, since they are failing to show. No one knows where they are. There's no updated address whatsoever. They do not have an attorney. There's no order of entry proving that they have one. So guess what? Now they're going to move forward and continue the hearing on the merits. So that's how this works. So they're like, we're not going to keep trying to do this. In order that this motion be heard without notice to Petition, they're not going to keep doing it. In order that this motion be heard in writing in accordance with Rule 23 sub 6.8. So they're not going to keep doing this. They're not going to keep trying to find these people and try to wait for them, to show up for once, or send their attorney to say. I mean, if they had an attorney, good God, the attorney could actually show up on their behalf and they still wouldn't have to show up. But they're not even smart enough to hire an attorney and get their attorney to show up on their behalf. The attorney would have to submit their order of entry, and the attorney would just be there on their behalf as their representative. They would not even have to show up even if they had an attorney, because the attorney can stand in their place. They're not smart enough to do the basic stuff because they don't want to do it. They don't want an attorney. They don't want to go through this. They want to take your money and keep running. So that's what they're doing. Order relieving the enforcement branch of its obligations to the respondents pursuant to Rule 27.1, 2, and 3 and Rule 3. Yeah, so they're tired of trying to get these people to show up. That's what this whole thing is all about. And then you can see the next page, the grounds to which they are establishing this in this motion. They establish in this motion basically saying this is why, here are the reasons why we need this order granted. All right. So they were served on the 24th August. On the 25th of August, NOH was issued. The SOA and NOH were both posted to the Capital Tribunal's market website. So these dumb petitions could have just went on the website and saw that they had a notice of hearing there. Novatech incorporated on September 26, 2019. Under the business companies, I'm not going to read all of that, but you guys can see these are just kind of some of the facts of the matter to try to, for them to establish why this motion needs to be granted and why they're seeking this order. Their addresses, even for, like you see here, Novatech's last known registered agent of the company, that's obviously not a viable address. The last known address of the registered agent in Novatech is this P.O. box number. That's not obviously, valid either. December 1st of 2022, because they've been trying to finish this thing out for a while. It's been over a year. The FSA received a request from the registered agent for Novatech to resign as agent of record. So it is, yeah. So they have no one representing them on any level. Obviously her email address is ineffective. So there's no way to get in touch with these folks. And you guys can see here, they have more than enough reasoning to establish grounds as to why this order needs to be granted. And so that they're relieved of this. Then they have their evidence, and then of course, last page here, you see the litigation on behalf of the OSC. You don't see the litigation on behalf of these dumb petitions because they don't have an attorney. They don't have an attorney. They don't have an attorney. So this is what happens. They don't have an attorney. All right. So that's that page. All right. Then you guys can see here, this is the notice of hearing that was issued on November 23rd. Basically saying when they, instead of it being on November 27th, it was going to be heard on December 7th. It didn't matter either way because they weren't going to show up. So, it is what it is. And then, okay, so here's the order that was granted, relieving the OSC's enforcement branch of any responsibilities for serving any notices, any summons to these dumb petitions moving forward. And this case will also move forward without them. So the order states that basically it is ordered that they are no longer obligated to try to file a notice with them. Staff is permitted to bring this motion without notice to the petition. They don't have to give them any more notice. They've given them over a year's worth, and they've tried in every attempt to actually track these idiots down, and they don't want to participate. I mean, this is their pattern of behavior anyway. If you guys were to even read, other cases, lawsuits, civil proceedings against Novatech and these dumb petitions, you will see that they don't show up for hearings, whether it be in a court or a hearing with an agency. They don't show up. They've had 3 lawsuits filed against them before they even started this scam Novatech, and they did not show up. They don't care. So people are not going to keep wasting resources trying to give them a chance. This was not rescheduled. This is proof that hearing from November 30th to December 7th was not rescheduled to give these dumb petitions an opportunity to do anything. They pushed it back on their own accord because they want to be able to have the hearing conducted where all of their representatives can be present. It's for their convenience at this point, the OSC, not these dumb petitions. They don't have an attorney. They've never had anyone represent them to come into these hearings. They're not attempting to work anything out. They don't even want to be found to be issued a notice or a summons. So it was not rescheduled because they're trying to give the petitions the opportunity to do something. There's an order here saying they're no longer going to even give them a notice. So it has nothing to do with the petitions at this point. That little girl want to sit here and act like she don't know how to read a document and show up for a hearing. Oh, well, you've lost your opportunity to try to defend yourself. So it is what it is now. So anything moving forward has nothing to do with them, the OSC, giving these dumb petitions a chance to do squat. Because they're not. They don't have to at this point. They have an order now that was signed by the adjudicator. They've given them more than enough chance. They gave them over a year to respond to notices, to show up for hearings, to submit discovery materials, to prove their case, to get an attorney to come in on their behalf. And like I said, you would know if they had an attorney on these documents. You would see that order of entry. You will see the attorney's name and information, the bar number on the last page of all of these motions and orders that they're issuing. They don't have any legal representation. So they're not going to keep trying to they're going to go on based on the procedural guidelines that they have. But they've already exhausted every attempt to give these dumb petitions the chance to do anything. They're no longer doing that. So they didn't reschedule a hearing from December 7th, anything because of these petitions or Novatech. That's not why. They already have an order saying they don't even have to give them notice anymore. So, no, ain't got nothing to do with them. Not at all. Got nothing to do with them. All right, so people, this is why reading is fundamental. And understanding what this means from a legal perspective. This is past the point of giving these dumb petitions. That little girl, you are so done. It's not even funny. You have no idea what's coming up for you. And I have not missed the mark on this from day one. I have been spot on from day one about this whole scam crap of the buffoonery that is of Novatech. And I keep telling you all, they're not going to show up. Now they're not obligated to give them a notice to show up. They have ran out on the opportunities to even make a move. They're not going to be at any hearings. The hearings now are going to be based on the merits of the case and the facts and the evidence that they have, with the OSC has, and they're going to give a ruling from there. And then more than likely, they're going to turn it over to the courts. And then from there, the courts can handle it and see those contempts of the order, as a offense, and then issue a bench warrant. because that's inevitable. That's exactly what's going to happen. Yeah, it's not going to just sit there once the OSC gives a ruling. Oh, no, it's going to, no. It's going to go to a court. Trust me. I've been telling you all this. This is how it works. If you don't believe me, look this stuff up and read it. It's simple. It's very easy to read. And if you don't understand certain terms, just Google it. I have to do that sometimes too myself. I have to look up certain legal terms to understand what that means. And I do it all the time in my videos. I always show you guys the documents here, and I will look up stuff in real time if I don't understand it. But this is what we are here. And so basically there, waived the notice of hearing. Statement of allegations was waived. The requirement to staff serve all future processes on the respondents is waived. Staff disclosure obligations pursuant to sub rules 27 sub 1, 2, and 3 in respect of the respondents are waived, and pursuant to sub rule 21-3 of the rules, the merits hearing will proceed in the respondent's absence. The merits hearing will proceed in the respondent's absence. So this is going to move forward without this little girl, anybody with Novatech, any legal rep on behalf of Novatech or her ass showing up at this point. It's still going to move forward. So don't think that they're rescheduling anything because of these dumb peons. They are not. They are not. They're no longer doing it. They were never doing that, but I had to do this video so people can see why I keep saying they don't have an attorney. They're not going to get one. They're not going to try to participate to help people get their money back that they stole from. No, they're not going to do any of that. They're not going to do it. I'm not going to give you guys false hope. At some point, reality has to kick in. This is reality. So they're going to continue on with the proceedings. They're going to finalize this case, and it's going to be a ruling, and it's going to be submitted to the court. And then they're going to ask the court to intervene to say, you all need to issue a warrant for their arrest. Go find them. Period. Because if they continue to do what they're doing, they're going to go to jail. If they took down Sam Bankman-Fried, you think Cynthia Petion is above reproach? The devil is a lie. No, she is not. For all I care, they can throw her little ass in jail with next to Sam Bankman-Fried. Shoot. And the dude from Binance. All of them can be in a jail cell together. But no, we're past that point. We're past that point. So this is basically the order now. They're going to move on without them. They're not going to show up. They're not going to expect them to show up. And they don't have to allow them to, submit any documents at this point. It's too late. They're past that point. They have rules to follow, just like any other government agency or court. They have rules to follow. And they're giving them over a year. Y'all saw a December 22nd, 2022 date where they tried to get them to participate in these hearings. They didn't want to do it. So now that they've ghosted all of their victims and the OSC, you guys are going to have to file a claim with the OSC and hope that the disgorgement or the fair fund that's set up is enough to be able to help you guys try to recover something. Because that's the only way you're going to get some money back. It's not going to come from Novatech or these dumb petions. It's not. They've spent your money. Please stop saying they have $2 billion or hundreds of millions of dollars of assets. No, they don't. They do not. That's a farce. They have nothing. If they had that money, I can guarantee you it would have been seized already. That is not how that works. They would have put a hold. They would have required a court order from a court to seize their assets. But it would have been done if they had assets. Trust me when I tell you, they don't have any money. I would think if they had some money, they would hire an attorney to represent them in this. They don't have any money. They're broke. They spent you people's money. So, this is the last notice posted The December 7th hearing will be heard instead on December 22nd, 3 days before Christmas at 10 a.m. by video conference. So I'm going to sign up. I encourage you all to do the same thing because I actually had signed up to attend the December 7th hearing. But I'm going to sign up for this one, so you guys can get an idea of what's happening and why I'm reviewing these documents. You know, this is enforcement proceedings at this point because they violated the cease trade order. You guys, if you go back to the statement of allegations, they violated that order. And I already told you all that government agencies have the power to enforce an order. They violated it. So this is why they're having an enforcement proceeding. Typically, when there is a violation of the order, the enforcement hearing is basically set to determine if you intentionally and willfully violated it, and to determine if you're going to be held to contempt and what that penalty is going to be. They're going to be held to contempt. And the penalty hopefully will be issuing of a bench warrant order that they will have to get from court. But they will get it. And they will have a warrant issue for their arrest. It's going to happen. I've been saying that. That's the point of these enforcement proceedings. They would not have an enforcement proceeding if they did not plan on taking action and actually penalizing them for violating the court order or the cease trade order. They wouldn't do it. It would be a waste of time that they felt like they weren't going to do anything past that point. So, no. They're going to do it. So I'm registering for the hearing. I did for the 7th, but they didn't have it. So, even better. They're not rescheduling anything because of these pettons. As I've said before, they're pushing it back based on them making a decision to do it, the OSC. Not because they're doing the pettons or the Novatech a favor. They're not. They don't even care if they participate at this point. They have rules in place that allows them to waive that service. They're no longer expecting them to show up. So it's going to move forward based on the merits. And that's it. This is not about doing them a favor. The pettons giving them an opportunity to do anything. They have an order where they don't have to. Bottom line. In the OSC, trust me, they're not going to give them a chance at this point. Because why should they? It's ridiculous. I wouldn't either. I've been exhausted of Novatech 5 months ago. I mean, you know, they're not trying to do anything other than keep you all on edge with their nonsense. You know, got still morons putting comments in people's videos. Yeah, keep on thinking this is nothing. Good luck to that. So either way, I've just registered. I hope you guys register. Lady Luck will be in attendance because I just want to witness this whole thing go down as it should. But I want you guys to be safe. Please file a complaint with the OSC if you're in Canada, with the SEC if you're in the US, the FTC, because at the end of the day, this is going to end up the same way it ended up for, you know, FTX, with Binance. They're going to jail and they don't have any money. All right. So you guys got to stop this whole utopian mindset stuff. You got to stop. Do yourself a favor. Just file a complaint, and hopefully enough funds have been raised in the disgorgement or a victim's fund of some sort where you guys can recover something. Even if it's a third of what you've lost, you know, you get something back. But it won't be from these dumb pettons or Novatech at all, because they don't have any money to give you all. It will come from the disgorgement or the fair funds. All right. That's all I got. Please, in all that getting, get some understanding and read some stuff and research. And, you get these little dumb bots in your comments sections talking about, this is nothing. They're not, the OSC is a joke, all that stuff. Well, they've been saying that for over a year anyway. I mean, that stuff don't faze me because I already know how this turns out. This is why it's important to understand things from a legal matter. This is why it's imperative. You can be able to read these motions and orders and understand what's happening. And until I see an order of entry from their attorney, they don't have one. So, all right, deuces.